Black people are probably more likely to have a record, which then, based on the score sheet, would give them a higher sentencing score. So I'm curious if that sort of, factors into it as well in terms of kind of the intersection between, disparities in policing and prior record in terms of convictions on the score sheet.
Yeah, I think they need to look at those guidelines again. I like the way the federal system evolved. By the way, when I started practicing, there were no guidelines in federal court or state court. And then I believe it was the federal system that came in first, and that was pretty much mandatory. If a judge were going to sentence outside the guidelines, they'd have to give good reasons. Today, as you probably are aware, because of some U.S. Supreme Court decisions, the federal guidelines are advisory only. And I like that idea because it gives a judge a sense of what the guidelines are, but they're not bound by them at all. And they can go above them or below them without giving any real, or certainly they don't have to justify it as much as they did back when the guidelines were mandatory. I'm not a big fan of guidelines. I understand why they're around to avoid disparity. You get a Northern Florida right-wing conservative judge sentencing someone for possession of a pound of marijuana in a very rural town in upstate Florida. The guy's going to go to jail for 2 years, and in Miami, they're going to get pretrial diversion or they're going to get probation. So there is some logic to the guidelines, but I think they can solve that problem real easily. Make the guidelines advisory. And that would help a lot. Judges wouldn't be hindered by for example, what you mentioned, someone born in a certain culture and area, and they're going to develop some prior convictions here and there, and those things add up. So making the guidelines advisory would help that issue, I think.
And you feel like that would strike a nice balance in terms of kind of balancing discretion versus structure, because obviously, either one of those on the extreme could be negative, right? If actors, judges have too much discretion, right, that could be a bad thing. But too much structure, like you said, then you can't take into consideration mitigating factors and things, and so you feel like that's a good way to sort of balance those two.
Yeah, I mean, in an ideal world, I think judges should have absolute discretion to do what they think is right, and then we get back to who are our judges? How are they being appointed or elected? How are they being put on the bench? So if you fix that first problem and you have judges who are experienced, who are vetted, who really care about public service, then you're not going to have as much of an issue with disparity, because presumably these are experienced judges who care about what they do and are fair and do the right thing. Very interesting. Just can't lose sight of the fact that, there's a perception in the public that prosecutors do everything possible to win their case. Defense lawyers do everything they can do to win their case, and the judges are just neutral referees. Well, it doesn't really work that way. Prosecutors are there to see to it that justice is done. If that means dropping a case, dropping a case. If that means not fighting on an issue, it means not fighting an issue. It's just to do the right thing. Defense lawyer's job is to win at all costs, so long as what the defense lawyer does is legal and ethical. We're not here for justice. And that sign above the judge that says, "We who labor here seek the truth"? You couldn't have a more false statement. They don't seek the truth. Oftentimes, judges suppress the truth. Happens every day. What is a motion to suppress? It's real evidence obtained by the police that incriminate the defendant. It's truth. It's real, but it was obtained illegally. It was obtained in violation of, say, the Fourth Amendment. So a judge said, I'm going to suppress this true, real evidence, and the jury will never hear it. So we who labor here do not always seek truth. We who labor here seek justice, would probably be more appropriate. So you can put that down in your list. Change the signs. Change the signs from we who seek truth to justice.
Yeah, that's a good one. And so you talked about kind of the judge's role in that and seeking justice. Can you talk a little bit about the prosecutor's role in terms of seeking justice?
Yeah, and I teach this to my students at UM. I mean, if you're a prosecutor, your job is not to fight every little thing. Your job is not to win. That's not your job. Your job is not to win. That is to get a conviction and send someone to jail for as long as possible. Your job is to see to it that the right thing is done in every case. And that's a very hard thing to define. What is the right thing? What is justice? But taking it to the more practical level, it means if you feel you can't prove a case beyond a reasonable doubt, even though you think the guy is 100% guilty, but you just can't prove it, you've got to drop the case. It means that if you have overwhelming evidence to put someone away for the rest of their life, that you look at the case and go, I don't think this person deserves to go to jail for the rest of their lives. I think they deserve this. And when I talk to the defense lawyer, I'm going to agree to this plea. And that's the job of a prosecutor. It's a pretty noble job. So is a defense lawyer's job, because there's no one else to stand up for the Constitution ultimately and make sure it's enforced than the defense lawyer. So,
right. And in terms of this, this kind of win at all costs mentality that some prosecutors might have, do you think, sort of going back to what you were saying earlier in terms of these high acquittal rate that they've had recently in the state attorney's office, do you think that sort of factors into it, or is it just that those were just, cases that just were not strong cases, and for whatever reason they got an acquittal?
Right. I mean, not knowing the cases, I couldn't tell you whether they were strong cases or weak cases to start with, but I'm sure part of it has to do with attitudes of jurors. When I started practicing in 1982 and I tried a case, one of the things during jury selection would be to ask jurors whether they think, does anyone here think that just because a witness testifying as a police officer, maybe in uniform, that they're more believable just because of that than a civilian? And, you get some hands saying, cops, should have a higher standard. They're the good guys and all. Today, I get more hands saying, I think because they're cops, they're less believable.
Oh, that's interesting.
You never heard that in 1982. You do hear that today in courtrooms. It's not unusual. So I think, to answer your question, some of that is a function of that. It's attitudes towards police, which I think is healthy. Skepticism of investigations, skepticism of police officers for having biases, lazy law enforcement not doing a thorough job. I think jurors are way more critical today. And also the CSI phenomenon. We're bombarded with these TV shows where every criminal investigation includes DNA and videotape. And the run-of-the-mill criminal investigation doesn't have any of that. And when a juror is picked and they sit on trial, it's like, where are the fingerprints? Where's the DNA? And if a case doesn't have that stuff, prosecutor has a tougher time.
And how much of that do you think the sort of changing attitudes among juries is related, if at all, to the demographics or the diversity of juries?
Oh, completely. Take New York City. If you're a criminal defense lawyer and trying a case in the Bronx versus Midtown Manhattan, same city, you're going to get completely different jurors.